If you've ever had a friend, coworker, or loved one go through the family court system, then you know the court is often slow, backlogged, and it's sometimes inconsistent. And we know that sometimes you just can't agree, and mediation isn't going to work. So court may be your last resort. Let me tell you about an alternative. I'm Jenny Bradley, founder of Triangle Smart Divorce in Cary, North Carolina. We help people make smart decisions when getting divorced, and we think it's smart to avoid long legal battles in court because of the time, money, and energy wasted in the system. Now, please understand that I'm not knocking judges. We have many wonderful judges in Wake County and the surrounding areas, but the truth is there isn't enough time on the court calendar to hear all the cases that need to be heard as quickly as they should be heard. Having overworked and overloaded judges leads to long delays in resolution, and often cases are heard in a fragmented way. One day you'll have a temporary custody hearing. Months later, you might have a temporary support hearing. And typically, more than a year later, you'll have a trial dividing your property and your debt. Somewhere in there might be a permanent custody trial. And then, after your property and debt are divided, you'll probably have a permanent child support and alimony trial. This doesn't even include all the scheduling hearings and the motions that need to happen to move your case forward. So what's the alternative? Arbitration. Instead of going to court and having a judge make decisions about your future, you agree to let a well-trained, experienced family lawyer be the decision maker and resolve your disagreements. There's only a few areas of family law that an arbitrator can't handle. Granting your actual divorce, granting an adoption, legitimating a child, terminating parental rights, or granting guardianship. Those are the only ones I know of. That means an arbitrator can decide everything else in a family case, down to who gets the Xbox account. But that's not even the best part. The best part is that you schedule arbitration on a particular day and proceed on that day. No getting bumped off the court calendar. No need to reschedule because mandatory mediation hasn't been attended. No waiting around at the courthouse all day to see if a judge has time to start your case and carries you into the next day. You schedule the day and you move forward on that day. If you choose, you can avoid fragmentation and have everything heard at one time. Doesn't it make sense to have the whole big picture decided at once? Custody affects child support, which affects spousal support, which can affect what should happen to the house. Custody, cash flow, and assets are all interrelated. Why not have them all resolved at one time? And the arbitrator has to give their decision in 30 days. In the court system, decisions can be given right from the bench, or a judge can take a matter under advisement. If the decision is under advisement, you don't know when the decision will come. Planning is hard. It might be next week, it might be next month, or in some cases we've heard about, it could be more than 3 to 6 months. Can you imagine the pins and needles you're sitting on, waiting to know what your future holds? It doesn't have to be that way. If you just can't work it out with the other side, but you know you don't want to go through the system, give us a call. We'll be happy to help you decide if arbitration is a smart decision for you.